Okay, the recording is on, and I have 5:33, Fiona. Does that work for you?
Yep, that works for me.
Okay. Shall I read remote access information, or shall I read item number 1?
Cheryl, can you state what meeting it is and the date and so forth, just for our recording purposes?
Yes. Today is September 15, 2020. The time is 5:33 p.m. This is the Complaint Committee of the Sunshine Ordinance Task Force. It is a remote, regularly scheduled meeting. We have a call-in number and a meeting ID for those who wish to participate. Please use those numbers. Chair Hinsey, how would you like to proceed?
Would you read the remote access to start, please?
All right. Okay, remote access to information and participation. In accordance with Governor Newsom's Executive Order N3320, declaring a state of emergency regarding the COVID-19 outbreak, and Mayor London N. Breed's proclamation declaring a local emergency issued on February 25, 2020, including the guidance for gatherings issued by the San Francisco Department of Public Health officer. Aggressive directives were issued to reduce the spread of COVID-19. On March 17, 2020, the Board of Supervisors authorized their board and committee meetings to convene remotely, via Microsoft Teams, and will allow remote public comment via teleconference. Members of the public may participate by phone or may submit their comments by email to Cheryl Leger at sfgov.org. All comments received will be made a part of the official record. Sunshine Ordinance Task Force agendas and their associated documents are available at sfbos.org/sunshine. We have a public comment call-in number, 415-906-4659, a meeting identification number of 723-548-840#. As the COVID-19 disease progresses, please visit the Sunshine Ordinance Task Force website regularly to be updated on the current situation as it affects the legislative process.
And then, Cheryl, could you also read for me our meeting decorum, please?
Yes, okay. Meeting decorum. Any member of the Sunshine Ordinance Task Force may call for decorum due to disorderly conduct of meeting participants. Persons who engage in threatening and or menacing behavior may be asked to leave. So in this case, we will turn you off.
All right.
All right.
Yes, thank you. And would you please go ahead and call item 1?
Item number 1, call to order, roll call, and agenda changes.
Would you go ahead and call the roll?
Yeah, I will, just a second. I just want to write this down. Josh Wolf?
Here.
Member Wolf, present. Member Yankee?
Present. Member
Yankee, present. Chair Hinsey?
Present.
Chair Hinsey, present. We have a quorum. I am not aware of any agenda changes. Does anybody else know?
All right. Perfect. Hearing none. Public comment on agenda changes?
Yes, hello.
Go ahead.
Peter Warfield. Go ahead. Mr. Warfield, you get 3 minutes.
Oh.
And you may begin.
Am I getting to speak?
Yes.
Yes, go ahead.
Thank you for the agenda. Thank you for the reading of what you read earlier. This is Peter Warfield from Library Users Association. What I wanted to ask was that you change the future agendas as to their boilerplate to give a little bit more explanation, not so much why you are doing remote meetings and what the justification is, which I understand and which you have read, but rather a little bit more information for the public. As an example, the Board of Supervisors has a full page of instructions for the public as to how they can take part and make public comment. So there's nothing here about how to mute or unmute yourself or what the meaning of the system is when it says mute or unmute. There's nothing here about those sorts of things, and how do you know when you have been called on or not called on. For that matter, how do you know when your time is up? So I think it would be very helpful to the public to indicate what is going on. I did want to note that when I heard the meeting ID number read rather fast, as well as the phone number, I think reading it twice and very slowly so people can write it down would be useful. I think I heard the last 3 digits of the meeting ID being stated as 804. Now, maybe I heard it wrong. The quality here isn't real good, although I have a landline. But I thought I heard 840, and the last 3 digits of the meeting ID, in fact, what I see on the agenda that I've gotten is 804, the last 2 digits being
I'm sorry if I read it
incorrect.
incorrectly, Mr. Warfield.
Yeah, no, I understand that. I just wanted to, at the outset, perhaps a correction might be made about that for the benefit of the public. So that's what I have to say about the agenda, and hopefully some improvements in the agenda for the public, because the public isn't going to, question you or argue with respect to your justification, and, well, maybe they might, but that's a whole different story from how do I make myself known. Like, for example, right now...
You have 30 seconds, Mr. Warfield.
Thank you for that as well, and that's useful to know too, especially for folks who don't have a timer. But well, whether you're giving a warning or not is useful to know as well. But as much as you can let the public know how to operate this, for example, I think you gave me some time to unmute myself, but there's nothing in the agenda that explains how to unmute yourself or what even unmute means. And I think I had to press like 3 times because I was already unmuted in the first place. Thanks very much.
All right. Thank you, Mr. Warfield. Other public comment on agenda changes and roll call? All right. Hearing none, Madam Clerk, would you please call item 2?
Item 2, approval of the December 17, 2019 and February 18, 2020 Complaint Committee meeting minutes.
All righty, colleagues. Any changes?
Any exchanges?
They look good to me.
All right, Matthew, I'm so glad to hear that. Both of them?
Both of them. Yep. I have
All
nothing.
right, great.
So I will move to approve them.
Do I have a second?
I'll second.
All right. Public comment on the motion to approve our minutes. All right. Okay. Hearing none. Madam Clerk, would you go ahead and call the roll?
I think you mean the next item. You said call the roll.
Don't we need to take it by acclamation or call a vote?
Yeah, I'm sorry. You're right. You're absolutely right. Do we want to take it by acclamation, or do we want to?
I would suggest you take a roll call vote on each item, just because members of the public are not seeing the video, and they would need a verbal cue that everyone is voting aye or nay.
Yes.
Okay. All right. Member Yankee?
Aye.
Member Yankee, aye. Member Wolf?
Aye.
Member Wolf, aye. Chair Hinsey?
Aye.
Chair Hinsey, aye. The motion to approve the December minutes and February minutes has passed.
All right. Perfect. Thank you. We have on those. Madam Clerk, would you call the next item?
Item number 3, public comment. Members of the public may address the committees on matters that are within the committee's jurisdiction but not on today's agenda.
All right. Is there any general public comment at this time?
Yes.
Go ahead.
Hi, Anonymous here. First, I wanted to thank you for returning to hearing complaints. And one thing I wanted to note is that in the future, you noted that you may not have DCA memos for this committee to analyze, and I believe you normally have those kinds of memos. Another public commenter in your last full task force mentioned perhaps you could offer complainants templates for the different kinds of complaints that they may have, including I think a member Tesfaye mentioned, it's helpful to have an attorney try to figure out what are all the points of evidence or things that you need to prove in order to make a specific kind of allegation. And so I agree that I hope this complaint committee or the task force as a whole might adopt some sort of optional templates for the different kinds of allegations, like the different sections of the Sunshine Ordinance. I have drafted one myself for the task force to consider as a public communication, and I hope you do consider it. It's under Creative Commons 0, so you guys can do whatever you want with it if you do want something like that. And it goes through basically many different sections of the Sunshine Ordinance and then kind of prompts the complainant for the kind of information that you might need to judge the complaint. Thank you very much.
Yes, Anonymous, I received your email and I have put it aside to be included with the October Sunshine Task Force hearing. I have it right here, literally.
All right, thank you, Anonymous. Is there any other general public comment at this time?
Yes, can you hear me?
Yes, Peter.
So go ahead.
So this is Peter Warfield, Executive Director of Library Users Association. We can be reached at libraryusers2004@yahoo.com. I appreciated what the speaker previously said. If we were in a real meeting, I would probably go up to him and say, what a great idea. Could you email me what you've got in the way of something that would make it easier for the public to file complaints and maybe understand how to do it as well. And this has to do with my general request for a little bit more information to make it easier for the public to function in the current circumstances and in general. I think I've mentioned it the full, well, let me start with the immediate issue right now. On this agenda, it was completely unclear to me why there were multiple complaints that had already been heard at this committee being heard again, it looked like. I am used to, in the past, having the jurisdictional questions resolved at the complaint committee, as well as some discussion and hearing with respect to the merits of the complaint. In the past, there was also a recommendation given by the complaint committee to the full task force with regard to whether the complaint committee saw merit in the complaint or not. That seemed then to change in the relatively recent past, and I believe Chair Bruce Wolf, wanted it to be going forward to the full task force without recommendation. Either way, it's not clear at all, and it took me a while of trying to scratch my head and then call your administrator to understand what's going on. Obviously, this is a change in your procedure, and this needs to be documented with some sort of explanation somewhere, either in your bylaws, with an amendment to them, or certainly on the agenda to explain why there's this second hearing. With respect to other benefits for the public, the whole thing has gotten all of the whole open government law and the changes to it are, as far as I'm concerned, very obscure. And I would like to see a summary. Thank you. I'd like to see a summary prepared by the task force that would make it clear what the procedures are within the task force, but also what the public can expect from the law, given all the changes that have come down from the state and the mayor. James Chafee, who was the first vice president and the second president of this body, made a kind of Bill of Rights, Sunshine Bill of Rights, and I think something like that would be useful for the public under the changed current circumstances. Thank you.
All right. Thank you, Mr. Warfield. Any other general public comment? Hearing none. A couple of things. Public comment. Hearing none. Public comment is closed. A couple of things before we go to our next case, to our first case about what we're going to do today. So, as the public commenter noted, you'll see on our agenda that a couple of these item cases have been heard already for jurisdiction. But today we're going to put those cases also through our normal complaint committee process, which is to basically do kind of a discovery and to make sure that we have information we need in the file of the various complaints to make sure they're complete, and then send them up to the full task force and decide where to go from there. And those cases that have already been heard have been heard for jurisdiction should be so noted on the agenda. And I have been informed by our administrator also that if your case is being heard today, most likely the case will be heard by the full task force at our October meeting, which would be October.
Yes, let me give you the date so that everybody knows. I want to be absolutely sure of this. October 7th.
October 7th.
October 7th is.
Show your phone.
Hearing.
There you go. Okay. All right. Cheryl, is there anything else you wanted me to cover about what we're going to do today before we get into our first case?
Are we all set? You guys went out for a minute. Is everybody here?
Yep, I'm good.
Matthew, I see you. Josh?
Yeah, you froze for me, Cheryl.
Yeah, I know. I don't know why.
Yeah.
I hear you now.
All right. As long as everybody's here now.
All right, Madam Clerk, would you call item 4?
Yes. Item number 4, file number 19098, complaint filed by Anonymous against Police Department for allegedly violating Administrative Code sections 6721, 26, 27 by failing to respond to a public records request in a timely and/or complete manner. This case was heard for jurisdiction on January 28, 2020 at the Compliance and Amendments Committee hearing.
All right. So we know Anonymous is here. Is there anyone from the police department on the line with us this evening?
Good evening, Sergeant Andrasek from SFPD.
Okay. All right. So the complainant and respondent each will have 5 minutes to start.
Okay.
And then we'll have Q&A process. Where we ask any questions, and then we'll decide where we go from there. So, Mr. Anonymous, would you like to go ahead and start with your 5 minutes when you're ready?
I am ready. Let me know when I can begin. All right.
You can
Hi,
begin.
Anonymous. Thank you. Thank you, Chair and Madam Clerk. So this is the Anonymous petitioner in complaint 19098 versus Chief William Scott and the Police Department. And we're going to begin, if you have the PDFs open, on item 4, part 1. For some reason, there aren't footer numbers, so I'm just going to go by the PDF page number. It's PDF page 15 in item 4, part 1. So last July, this is more than a year ago now, I filed a regular records request for the 10 most recent sent and received emails of each of various senior leadership of the police department, including a City of San Jose search of their personal devices. On July 15th, I had an initial response from the SFPD. They declared a CPRA 14-day extension. On August 5th, I received what appears to be an empty email from SFPD. It appears later on, this is actually just some sort of problem with getting emails from their portal, which is why I don't use their portal. Apparently, that is when they first started giving records in August 5th, and then they continued rolling responses through December 26th of 2019. September 13th, after a bunch of those records had been produced, I filed this complaint for 12 alleged violations of the CPRA and the Sunshine Ordinance. And on February 19th, actually, SFPD indicated there are still more records to produce. And just so the full request and everything is in here in the rest of the evidence documents, but just as an excerpt, basically we asked for an electronic copy in the original electronic format of these certain emails. This is back when I was doing basically an audit, a general electronic communications audit of basically every agency. I've changed the request to kind of be more narrow these days, but this is back when we were looking for metadata. The first issue, if you look at the second page, is whether or not they actually conducted a proper City of San Jose versus Superior Court 2017 personal account search. I believe it was insufficient. The SFPD told its employees that if you do not use your personal email and or mobile phone for work purposes, you would not have any responsive documents for item 2 and 3. And items 2 and 3 were the City of San Jose requests searches I asked them to do. However, that is not what the scope of the City of San Jose case requires. For example, and I believe a similar example is mentioned in Dennis Herrera's memo about the City of San Jose case, which is, for example, let's say a police commander, one that I requested records from, does not use their personal email for work purposes. But a subordinate officer emails that commander about police malfeasance, which is clearly about the conduct of public business, on that commander's personal email out of fear of it being tracked by their government email system. That email would still be subject to the City of San Jose, the scope of the City of San Jose case, but it would not have been produced to me because of their limited scope that they told their employees to do. The second issue is that they haven't actually provided me copies of the original records. You guys discussed this at some of my earlier cases. You can't print and scan email records, kind of destroying some of the information. It destroys hyperlinks, image information, other stuff like that. And you can't take emails, forward them, and then print the forwarded version of the email. Because when you do that, you actually take away the original information from the original email. You have to give me a copy of the original email. And if you look at the next page, this, I believe, SFPD now accepts, and they have corrected in future requests. However, they did violate this law at the time of filing this complaint, which, as if you remember from my last SFPD complaint, is what matters. SFPD, at the time this complaint was filed, did not key their redactions by footnote or clear reference to justifications. They would just basically provide me all sorts of redactions and not tell me which redactions and which justifications. After this complaint, SFPD, like many other agencies who have filed complaints against, have changed their practice, it appears, where they give a key. You can see it at the bottom here. They give you kind of like, okay, there's 11 different reasons we could use, and then each redaction gets a footnote or other clear reference to the justification as is required. But to be clear, they didn't do that when I filed this complaint. The next page is about email data and headers. We've discussed this at your IT committee meeting. Metadata is a public record. It must be justified when not provided. It must be minimally redacted. And you can also see your own prior order, SOTF 19044 versus the Office of the City Attorney. Now, what's great is SFPD does understand metadata, and they clearly know how to produce it, because for text messages, you can see at the bottom of this page, they do produce metadata databases in tab-separated electronic format that I can process. And as you can see, some of this information is not information you would normally see. Unfortunately, while they did provide some of this more technical information, metadata, they didn't provide from and to. Thank you very much.
All right.
It'll be great if you give 30 seconds, but yes, thanks.
Thank you, Anonymous. Our respondent from the police department, I'm sorry, I didn't quite catch your name, Sergeant.
Hi there, Sergeant Andrzejczyk.
Andrzejczyk. All right, you have 5 minutes.
Okay, thank you.
Okay, you ready?
Yeah, I'm ready. You guys ready?
Go ahead.
Okay, we did receive the request. It was actually for quite more than just emails. 10 recent sent or received. It actually requested all types of things, including Facebook Messenger and that type of thing, as well as a text message, We provided Mr. Anonymous with the text messages rather quickly. That's a much easier process for us to do. I am still processing some emails for certain members of the command staff. Unfortunately, due to the state of emergency with COVID-19 and then the riots and so forth, civil unrest that took place, it's kind of thrown me off my schedule a little bit. But I am still processing. I've recently provided some additional emails in the last couple of days, and I'm continuing to do so. I have maybe 2 or 3 more members of command staff that I'm attempting to have them get back to me with feedback on the redaction and so forth. I am not aware of any rulings on metadata, so I cannot speak to that. And I don't know about the comment about personal emails under San Jose. When I spoke to people, it was basically if you're not using your personal phone or email for any work-related purpose, then I would not expect you to have any documentation. That's all I have for you.
All right. Thank you. This matter is now with the committee. So, colleagues, start with any questions?
Sure. This is Matt. Question I have is to get to the point of personal accounts and devices. Is there a way for before this goes to the full task force, if the respondent could ask all of the individuals who were contacted regarding their communications to, check their personal accounts or devices for any communications they may have received that would be work related, even if they, do not typically use that personal email account for work?
Is that for me? I'm sorry.
Yes, I'm sorry. Yes.
That's yours.
Yes, I can ask them all to double check their personal devices and personal accounts and provide me with any work-related material at the time on the request.
Okay. Great.
Other questions?
And then maybe I'll talk to this since I was there for the IT committee hearings on metadata. So
Great.
we did have several discussions about metadata, and I think this ultimately went to the full task force, and the full task force found that metadata is part of the public record. So that's just a little background on this, that just a PDF version of the email won't be sufficient. That if the request is for the metadata, I believe the full task force has now held that the full metadata has to be turned over, obviously with any redactions that would be legally permissible.
And then also, Matt, did you at all at the IT committee talk about metadata in text messages?
I don't believe there was one specifically that we had talked about regarding text messages, but I think for this case, it looks like we do have the text message metadata. So it looks like it's the email metadata that's still missing. The complainant can correct me if I'm wrong here, though.
Yeah.
Is that a question for me?
Yeah. Is it just the email metadata that you're still looking for, Anonymous?
No, it's 2 parts. Yes, the email metadata is missing, and the text message metadata, as it says on bullet 3 on page 18. They gave me a bunch of text message metadata, but they're missing the basic to and from, so I don't know who's sending the message to who. So we do need that metadata for the text message.
Okay, so maybe the respondent can work on getting that as well for the upcoming hearing.
Yeah, would that be possible? Would that be possible to get the to and from metadata for the text messages?
So this is Sergeant and Draycheck. We need to and from info, at least for some of the text messages, or is that all? And then is the request about metadata separate from that? Because I'm not super technical.
Anonymous, can you clarify that, please?
I didn't completely understand the sergeant's questions. If my answer doesn't make sense, please clarify again. There's two parts missing right now. There is the from and to kind of columns of the TSV database that I was provided of text message metadata. If you'll notice on the bottom of page 18, you gave me cred ID, message ID, date, network, message, type, attachment count, and body. You're missing like who sent it and who received it. And then you're also missing email header metadata. If the task force allow, I can explain that more, but only if they want me to explain more.
Respondent, do you need more context?
I can look through what I have with respect to the text messages, and if I cut out the to's and froms, I should be able to work on that. Email metadata is not something I'm very familiar with. In fact, when I started this project, I wasn't having any luck saving, if you will, emails directly as PDFs. That's why I was printing and scanning.
Okay.
Also, that necessitated developing this footnote code sheets and penciling or writing those in by hand, because at the time we didn't know how to do overlay, redaction, that type of a thing. We'll figure that out. We're getting better with that. But I'm going to have to consult our city attorney on the whole metadata, because when you guys say we are allowed, of course, some redaction, but not others, I'm unclear as to what that redaction is, what's allowed and what's not allowed. So trying to reproduce 20 to 30 emails for each of the members requested with metadata is going to be a time-consuming task.
All right, Josh, you had a question?
No.
Okay. Yeah, if you could consult your, it's sort of going out of the bounds of what this committee's to do, but if you could consult your city attorney or your IT folks about the email metadata, that would seem to be a good next step. All right, other questions from committee members?
I was just going to add that I believe Anonymous specified the specific type of email formats that he's looking for. And so I would just kind of, piggyback on what you said, Member Hinsey, that, consult with your IT folks. There's a way in Outlook to save particular emails into this format that he's requesting that would bring the metadata along with it.
Okay, so committee members, do we feel that this is ready to go for hearing, pending the respondent's ability to get what we've requested?
I don't have any further questions for myself here.
Or would we like?
I think it's ready. I think it's ready to go whether or not the respondent follows through with what we've requested.
Right.
I agree.
Yeah.
So I guess I'll make a motion then that the records requested are public and to refer to the full task force for a hearing, since I think the jurisdictional issue's already been, decided.
Correct. Yes. Is there?
Who wants to second that?
I can second it.
All right. Thank you. Public comment on that motion.
I beg your pardon. Take the roll call. Is that what you said?
Looking for public comment on the motion.
I apologize.
Public comment is open on that motion.
Yes, can you hear me or not?
Yes, we can, Mr. Warfield. Go ahead.
Hang on a second.
And I'd appreciate the 30-second warning. Appreciate that.
Do the best I can. Go ahead, sir.
Yeah, this is Peter Warfield, Executive Director of Library Users Association. We can be reached at libraryusers2004 at yahoo.com. First thing I want to say is that it's very disadvantageous and unfortunate that there is no live link to the documents that have been referenced throughout this discussion on both sides, as well as from the committee. So, you know, when I move the, what do you call it? There's no little hand, there's nothing linking from file number such and such, there's nothing linking from where it says there's an attachment. So it was not possible to make as informed public comment as I certainly would like to. And I think that's very unfortunate all around. With respect to the complaint being brought, I think it raises a lot of very interesting and important issues. And I have to say that metadata was something that was a long time ago discussed. I've got a history with the task force, and library users does as well, over quite a number of years. And it seemed that metadata was a lengthy discussion that had happened some years ago. The police comment at one point that I thought I heard was that metadata would be supplied if requested. And I think that's very problematic because I think that metadata is and should be an integral part of what is provided. Let's go back to pre-computer days. If you sent a letter or a memo, you would send, as part of the letter, your from, name and address, and your to, name and address, as a part of a business letter. That was all standard. And it would be right on the document, whatever it was that was being sent or transmitted. So I think the comparable thing is precisely what now is called metadata, as though it's existing in some other realm or other world.
You have 30 seconds, sir.
Thank you. Of course, to and from is and should be part of what's going on and what should be revealed. So I think that, and metadata, for example, a searchable or non-searchable, that should be provided as well, and so should databases and spreadsheets provide the metadata. That just seems to me part of the document. And I don't see that email.
Sorry, your time is up.
I don't see email anywhere redactable as personal information in any law or Sunshine Ordinance.
Okay, thank you, Mr. Warfield. Any other public comment on that motion? Already hearing none.
Chair Hensey, if I could just quickly say something. I just wanted to say that the links to the attachments seem to be working just fine for me. If you look at, usually it's the file number that's clickable, but in this instance, because there were so many, I see that Cheryl put them below, and so it says attachments part 1 of 3, attachments part 2 of 3, and attachments part 3 of 3. And on my PDF that I'm opening up, those are clickable links that link to all the relevant attachments.
I just want to say for this particular case, there were hundreds of pages of responsive records. And that's why I had to divide it up. I couldn't put everything in there. So I picked like the first 2 responses that I got from the police department, and that was over 200 pages just for that alone. Mm-hmm. So it was extensive.
Thank you, Member Yankee. I was just about to click through, so thank you for that. Any additional public comment? All right. Hearing none, public comment is closed. Would you please call the roll, Madam Clerk?
Okay. Member Yankee?
Aye.
Member Yankee, aye. Member Wolf?
Aye.
Member Wolf, aye. Chair Hensey?
Aye.
Chair Hensey, aye. The motion to send to the full task force passes.
All right. Thank you. Madam Clerk, would you call the next item?
Item number 5, file number 19120, complaint filed by Anonymous against the Office of the City Attorney for allegedly violating Administrative Code Section 6721B and C, 26 and 27, by failing to respond to a request for public records in a timely and or complete manner, failing to justify withholding your records, and failing to provide assistance.
Okay, thank you. Do we have anyone from the city attorney's office with us this evening? All right. Hearing no one. It's Cheryl. Remind me again. What do we how do we normally proceed when a party doesn't appear at a
At a hearing, what we usually do is allow the other party to speak, and we make a note in the minutes that there was no communication from whoever the missing party is. That will be noted in the record. We didn't hear communication, and they were not present at the hearing. That's how we'll handle that.
Okay.
Does that answer your question?
Yes. Thank you. All right. Anonymous, you have 5 minutes.
Hang on. Anonymous, go ahead. Yeah, go ahead.
All right. Thank you, Madam Clerk and Chair. I just did want to notice, it is best to ask whether the anonymous petitioner for this file is available. There are a few other anonymous petitioners. I know I'm probably the most common anonymous, but there are a few others, so we don't want to get confused between them. But yes, this is my complaint file 19120 versus the City Attorney's Office. I just wanted to note, John Cote, who is usually the representative of Dennis Herrera's office, sent an email to myself and Cheryl via the SOTF email saying on Tuesday, September 8th, saying, quote, "We agree that this can proceed to the full SOTF," end quote. That was an email. And I believe that may just have been confusion over this jurisdiction versus jurisdiction and records are public issue. But because they and I both believed that we'd already heard this case at committee. We were wrong. But anyway, so in this case, I asked for records about Jeff Adachi and the raid on Brian Carmody. They provide numerous records about a 2,000-page document over quite some time. I just want to point out, when they tell you, well, it's 2,000 pages, over 1,000 of those pages are just copies of the Board of Supervisors agendas and the electioneering packets about Sunshine Ordinance. They had to themselves redact, I think, maybe 200 to 300 pages. And the key complaint here is that the City Attorney's Office, unlike most of the other departments we've brought complaints against, still have not learned the lesson, and they refuse to acknowledge that 67.26 requires them to justify their redactions. And this is a requirement. It's not a requirement only for some redactions or only when they feel like it or only when it's a certain size of document. You have to justify all of your redactions, and they did not do so. Even after filing the complaint, they were only willing to justify like the 20 of them that I pointed out are wrong. They admitted various of those are wrong. And you may wonder, why am I such a stickler about 67.26? Because exactly what happened in this case is probably happening to a lot of other members of the public, which is that the city agency just redacts whatever they think is subjectively sensitive. And without having to sit down and think that there's a particular legal reason to do each and every redaction and then state that reason and then be held to that reason both before this task force, the supervisor of records, and Superior Court, if it comes to that, they can be sloppy, just like the City Attorney's Office was in this case and has happened in many other cases. The difference in many other cases is those agencies like SFPD or DPW or whatever, they have now agreed that they do have to justify each and every redaction. The City Attorney's Office continues to maintain they don't have to do that. And that basically they only have to justify when I file a complaint and only the redactions I challenge. That's not the law. They have to justify all of their redactions and they have to justify all of their withholding of documents in writing. I can go into details of each and every redaction, and I'll give examples in the main task force of why these redactions are wrong. They've admitted various of them are wrong, and they're going to keep on doing wrong redactions and be sloppy until they have to follow 67.26 and 67.27, justifying all of their withholdings and giving a footnote or other clear reference to each and every redaction. Thank you very much.
All right. Seeing that we do not have a representative from the respondents' side, questions for our petitioner?
I'm sorry, I didn't hear you, Fiona.
I was just saying this is the time, since we don't have our respondent here with us, open the floor for questions from committee members for anonymous.
No questions from me.
Josh?
No questions.
All right, no questions from me either. All right, now our deliberations. What is your pleasure with this committee, members?
Well, it sounds like the city attorney, is on board with saying it's the full task force, and I think that's what we should do.
Yep. And this one has not been heard for jurisdiction, correct?
No, I believe it was.
It was.
Yes, the
Yes,
meeting.
it was.
No, it was, yeah.
January 28th, Compliance and Amendments Committee. It was heard. And I will tell you that I reviewed the email exchange between myself and Mr. Cote and Anonymous, and I made it clear to all parties that this case would go forward on the merits and that they needed to appear. And the agenda did go out to Mr. Cote and to their paralegal, Elizabeth Goldbrith, and also to their email, just their what do I call it, folder, where they accept filings, and everything is reviewed all the time in that office there. So it's gone to everybody.
Okay, perfect. Thank you. The chair would like to see if there is a motion on the floor.
Sure. I would move that the records are public and to refer it to the full task force for a hearing.
All right. Is there a second? All right.
Is there a second?
I'll second.
Josh?
All right. Yep. Yeah.
That was
All
Josh?
right. Yeah. Public comment on that motion.
Yes, if you can hear me, please.
Hang on.
Yes. There you go ahead.
Hang on.
Let me know
I
when
gotta
to
time
start.
you.
When do I start?
You can start now.
Okay, this is Peter Warfield, Executive Director of Library Users Association. Just a note on technology, I've been to many meetings where they massively put everybody's hand basically down. They mute everybody after public comment, and so you have to re-request to make public comment. When I did that at the first item, I went through a whole series of slow responses and confusion about where I stood. I appreciate that you are leaving this open for public to be heard, but it's a different procedure in different places. Again, I think that's something that would be useful to document. This is, again, a very interesting case. I'd like to assure the committee that not all city agencies are doing the proper redaction. We've had a long history and taken cases to the task force regarding improper failure to note each redaction and to note where it is and to note what the justification is. I can say that this has happened routinely and not in the distant past at all. So it's very important, I think, these specifics about having to note each redaction and so on. We have also experienced where the redactions are not at all clear. And I have seen redactions where a white piece of paper made it almost impossible to recognize that there were any redactions at all. It wasn't clear whether that was just a spot left blank, as an example. And that's why this is very important. I think all the redactions need to be clearly marked, and not in a way that you wouldn't even notice it when looking at the document or the page. those are things that I think are very important. And these actually are things that I think it would be useful, for example, for the task force to index or to make as a general rule when you have had routine rulings on this sort of thing, so that the public could know.
30 seconds, sir.
So that the public would know without having to search through a lot of orders of determination, that this is what's required and that you have ruled on it, and that it's very important and valuable for the public to know exactly what's been redacted where and for what justification. Thank you.
All right. Thank you. Any other additional public comment? Hearing none. Madam Clerk, would you please call the roll?
Member Yankee?
Aye.
Member Yankee, aye. Member Wolf?
Aye.
Member Wolf, aye. Chair Hinsey?
Aye.
Chair Hinsey, aye. The motion to send to the task force passes. Okay.
Thank you, Madam Clerk. When you're ready, would you call the next item?
Yes, I will. Item number 6, file number 19101, complaint filed by Ray Hartz against President Mark Buell and the Joint Zoo Committee for allegedly violating Administrative Code Section 6715D, 6716, by failing to place the submitted 150-word summaries of public comment into the meeting minutes. He is specifically referring to a meeting of August 15, 2019.
Okay, Mr. Hartz, are you with us? Mr. Hartz? Cheryl, have we heard anything from Mr. Hartz?
No. No, I haven't.
Okay. And anybody from the zoo with us? Okay. In this case, I believe Cheryl and or Victor, do we table the item?
We can continue it to.
I believe it's in our procedures or our complaint procedures that we should table the matter and inform the party that it is tabled and give them an option to reopen it.
Okay. Sounds good. Does that sound agreeable for folks, since we've not heard from either party?
Do we table it or do we continue it to the next meeting? I forget if we give them.
I believe we should table it. Otherwise, this item goes into limbo.
Gotcha.
Unless we hear from somebody.
Yeah, I believe we give continuances if one party doesn't show
Gotcha.
up.
Okay, yep. That makes sense.
Yeah.
It's been a while.
Yeah, exactly. It's been a while since I've been to this committee,
Yep.
so I'm thankful for Cheryl and Victor for reminding us of procedures here.
So do we want to take a vote on that, or do we just want to table it?
The chair would like to entertain a motion.
Sure, I would move to table for lack of appearance by either party.
All right. Is there a second? I will go ahead and second it myself then. Madam Clerk, would you go ahead and call the vote?
Public comment, public comment.
Wait, my apologies, Mr. Warfield, thank you. Go ahead for public comment.
Hang on.
Thank
All right,
you.
Mr. Warfield, go.
Thank you.
Go ahead.
This is Peter Warfield, Executive Director of Library Users Association, and we can be reached at libraryusers2004@yahoo.com. First of all, I want to say that I think that the complainant, Ray Hartz, is doing a great public service. I think of him as a sort of a heavy-duty icebreaker, pounding through the ice and making a pathway for others, as well as an education for others about what people have a right to. Second thing that I want to say is that I understand what you're doing, I'm not clear why you went ahead with the previous item, the complaint against the city attorney. Without the presence of the city attorney, you're sending it forward, which I think is good. But I do think that the requirement to have a complainant present at certainly this kind of a hearing, I think is completely and unnecessarily onerous. There's no reason in certain cases why there's anything added by the presence of the complainant. In this case, I believe the 150-word summary that was presumably handed to the organization is noted and I believe provided, and the lack of the placement of the 150-word summary into the minutes is also something that I think is determinable fairly easily. I do think that it is very unnecessary and unnecessarily onerous to require the presence of the complainant, as I said, when there's fairly straightforward documentation. And for that matter, it seems to me it should be up to the complainant whether the complainant wants to be present in order to answer questions and to ease and to make more likely the complainant's successful conclusion of the complaint. I still don't understand why the complainant is required to be present, but apparently the respondent does not. That's a completely unequal sort of a thing. The respondent should be present, I think, but if the respondent isn't there, then, well, as I said, let's stick to the complainant. I think it's, in certain cases, fairly straightforward, and I think the complaint should go forward unless the complainant asks for some kind of an extension or has a reason for not showing up and would like to have a hearing with them present. Thanks very much.
Okay, thank you, Mr. Warfield. Any additional public comment? Okay, hearing none, would you please call the roll, Madam Clerk?
Wait, one
Yes?
quick thing. We have no communication from the complainant in this case. We have no indication he wants us to move forward. I just want to verify that.
No, I mean, I haven't received any communication, but I know, I mean, everybody's gotten the, everybody got the agenda. I certainly sent it out.
Right. I just, after hearing Mr. Warfield's comments, wanted to make sure that there wasn't a request by Mr. Hartz to move it forward.
I didn't hear anything from Mr. Hartz.
Great. Thank you.
And just so for all parties, we will inform Mr. Hartz of the action, and he can reopen it if he informs us within 30 days.
Thank you, Victor.
I think it says 60 days in the
I thought it was 60 days.
Yeah, you may be correct. I haven't looked at it in quite a
Yeah,
while.
I was able to find them.
Yeah, I
But
think
he will be given the opportunity to keep it open if he communicates with us.
okay, perfect. All right, hearing no additional public comment, Madam Clerk, would you go ahead and call the roll?
Member Yankee?
Aye.
Member Yankee, aye. Chair Hinsey?
Aye.
Chair Hinsey, aye. Member Wolf?
Aye.
Member Wolf, aye. The motion to table the case passes. Or table the matter. Okay, item number 7. We ready for item number 7?
Yes, go ahead. Thank
Okay.
you.
Item number 7, file number 19145, complaint filed by Chris Kors against the Police Commission for allegedly violating Administrative Code Section 67.5 and 67.21 by failing to respond to a public records request in a timely and or complete manner.
All right, do we have the respondent with us? Or the petitioner, say,
Petition.
Mr. Ford?
Yeah, I'm here.
All right,
I'm here.
and then do we have still the sergeant with us for the police department?
Police Commission.
I'm sorry. We have the police commission with us?
Yeah, Sergeant Youngblood, Secretary of the Police Commission.
Perfect. Thank you. All right, Mr. Ford, when you're ready, you have 5 minutes.
Are you ready, sir?
Great. Let's go.
Go for it.
All right. On 3/6/2019, I had a hearing before the San Francisco Police Commission. After the hearing, I received both the transcript and an audio recording of my hearing. Upon review of both the transcript and audio recording, I noticed that there was very important dialogue missing from both. I had the audio recordings forensically analyzed, and the results concluded that the anomalies in the recording are not natural and that the recording is not an authentic representation of the events as they occurred naturally. At 11 minutes and 38 seconds into the recording, you hear my attorney, James Lassart, getting cut off mid-sentence. James says, he is, ... Then there's a pause, then a sound blip. Then it awkwardly goes into questioning by a female voice. This occurs on page 10, line 21 of the transcript. Here's the actual playback. Please listen.
And by the way, he's not on any paid status. He's
Your client call 911.
That anomaly is where the dialogue is missing. The second point of concern I have is a possible error that I found in the last 15 seconds of the first audio recording. Page 15, line 18 of the transcript is where this occurs. I say possible because, to the best of my knowledge, the deliberations were to be on the record, but they were off the record. Either Sergeant Ware or the commission president at the time, Robert Hirsch, shares my concern. Here's the playback.
But even if he
excuse me, you need to have the deliberation on the record.
okay, so even if he wins the appeal, are we on the record? No, we're not.
It's concerning that the deliberations are supposed to be on the record, but they're off the record because the court reporter stepped out. Over the past several months, in several emails, I have asked the San Francisco Police Commission to provide me the rules, policies, and procedures that the court reporter Anna C. Greenlee was required to adhere to, but they have still not provided this information. On February 5th, 2020, I received an email from Sergeant Youngblood stating that there are no chain of custody logs for the jump drives that contain the audio recording of my hearing. On March 2nd, 2020, I sent an email to Sergeant Youngblood asking for four important questions. Since the chain of custody logs do not exist for the recording, including the jump drive, who has access to the recording, including the jump drive? Are there policies and procedures in place to ensure the integrity of the jump drive without a chain of custody log? Prior to the court reporter Anna C. Greenlee leaving the hearing on 3/6/2019, did she provide the commission an unedited draft of the hearing? Regarding my hearing that took place on 3/6/2019, what is the make and model of the device that allows recording of the room audio to a USB or SD card? I still have not received answers to these questions. The dialogue that's missing from the altered transcript and audio recording influenced the police commission's decision to terminate me, which simultaneously made me a member of the public. To say that I don't have access to the original recording because I'm a member of the public, when that same recording influenced the commission's decision to make me a member of the public, is absurd. By the time the recording was complete, I was already terminated and a member of the public. Therefore, I could have never requested this recording while still a police officer. But just using plain common sense, to claim that I can't get a copy of a digital original of my own hearing is absurd, especially when I'm the one requesting it. The San Francisco Police Commission has the discretion to disclose the evidence that we are asking for. I am requesting that the Commission use their discretion to provide us that evidence and transparency so we can bring closure to this matter. If they don't, we're asking the SOTF for assistance. I'm requesting a copy with a declaration under the penalty of perjury that it is of a digital original. I am also requesting for a report under the penalty of perjury identifying the machines and devices on which this specific recording was made. Thank you.
Okay, thank you. Mr. Youngblood, you have 5 minutes. When you're ready.
Hang on. Sergeant Youngblood, go ahead.
So the
Go
police
ahead,
commission has given Mr. Kors a copy of the recording, but to reiterate, this recording has been provided to Mr. Kors as a former employee asking for his personnel record.
He has not been provided this as a public records request. So he was given a copy. The day that he asked for it, he received a copy of it due to the fact that he is a former police officer asking for his personnel records. He has been provided with that copy, excuse me, and he has also been told that he is able to come to the police commission office to listen to the original as well. As far as the wanting to hear or see the recording equipment that that this took place on, this is not owned by the police commission. This is owned by City Hall. So we are not able to provide that information, and we have directed him on who to call and how to get that information.
Do you have anything more to add?
No, just other than to say that this is not jurisdiction of a public records request. This is a former personnel asking for their personnel records, which have been provided. Thank you.
Okay. This matter is now with the committee. Colleagues, what questions do you have at this time?
I'm sorry,
I've
did
got
you
some
ask it?
questions.
Go ahead, Josh.
I guess the first question, and either party can answer this, I'm just trying to understand what this meeting was. Is it like, this is a police commission hearing, so does that look like a closed session of the public police commission meetings, or is this a whole different thing than the police commission that we're familiar with?
This is a closed session of a discipline hearing at the police commission.
So it's a totally separate meeting from the public police commission meetings?
Correct. We have
or
open
is it a
session,
closed
and then we
session
go.
during the same meeting?
It is the closed session of the police commission meeting.
Great. And so I guess my next question is, are you contending that the complainant's assertion that there is a break in the audio is incorrect, or are you acknowledging that that break exists?
I can hear the break that he is talking about. Whether it is his attorney being interrupted, I don't know what that break is, but the recording that we have matches the transcript that the court reporter who was there live recorded on her transcript, which they do match. He has been provided an exact copy of what we currently have.
Okay, but it's recorded as an audio file. And so is the audio file completely uninterrupted? Or was there a pause in the audio file during the recording?
There was an anomaly. And if you look at the forensic report, it clearly shows that this is not a natural event. This is an edit, an alteration. I know exactly what was said at that hearing, and it's missing right at that sound blip, at that anomaly.
I understand what you're suggesting, sir, and what I'm trying to get at is if we can access in some way the original file and ascertain whether or not it is still in integrity, that should illuminate your theory one way or the other.
Yes, it can. Through forensics, if we get the original file, we can absolutely determine if that audio was tampered with. Right now, we have an altered audio that matches a transcript. So what we have now is we've proven the audio is altered. Since the audio is altered and it matches exactly to the transcript, they're both altered. But we would love to have the digital original, get all the conclusive information. We'd love for someone to tell us what was the make and model, serial number of the equipment that was used. The police commission knows. From what they told me, they said they couldn't tell me because it was under some government code that I could potentially hack into their system, or Stacy can explain the government code. It's just unbelievable. Like I'm going to do that. But anyway, did I answer your question?
Yeah, I think I've heard the answers. I would encourage you to file a public records request in a formal fashion around that make and model. That is an issue that is clearly within the jurisdiction of the task force. We haven't gotten into the meat of whether or not this really is something that's accessible to a member of the public at all. And I think as we unfold that, it's going to really impact our thoughts on jurisdiction. But if you're trying to get the make and model of the recording software, there should be a way to pursue that through public records as a public citizen. And that's something that undoubtedly would, or presumably would fall within our jurisdiction.
Correct. But Stacy Youngblood, like I said, stated that I can't get access to that. Isn't that correct, Stacy?
No, I did not say that.
In an email, it's written. What did you state in that email then, Stacy?
So I don't think we can really have a back and forth between the complainant and the respondent.
Right.
I'm going to hand things back to our chair and let her take this meeting from here.
So, Mr. Flores, are you able, the email you referenced, are you able to reference the page number in our packet? In our packet?
I'm sorry, can you please repeat that? I didn't understand.
The email you just referenced that you claimed that Mr. Youngblood sent to you, can you reference that in our packet?
Absolutely.
Okay.
Okay. And so what exactly is it that I'm supposed to be doing here? I'm supposed to be emailing the Sunshine Ordinance Task Force a copy of Stacy Youngblood's email and a request?
Not right now. I'm asking, is that particular email that you just referenced with this Youngblood, is that in our packet? Packet of evidence that was provided to you by our clerk in advance of the meeting?
I'm sorry. I'm so sorry. Can you repeat that one more time, please?
Sure.
Something. Okay.
If you referenced an email that you were asked Mr. Young, an email exchange that you had with Mr. Youngblood, is that email exchange in our packet at all?
I believe it is.
Okay.
But I can double check, but I believe it is, yes.
Are you able to reference a page number offhand? Take a look for that.
Right now?
Ideally, yeah.
Okay, let me, I can read off the actual, I can try to find it right now. Let me just double check here.
I just want to make sure it's in our packet. That we might be. Because before this goes to the full task force, we need to make sure that our evidence packet is complete. So, and I also have another question for you while you look. Do you believe that you made this request as a private citizen? As a public record request?
Can you repeat? I'm sorry. Can you repeat that one more time? You're kind of fuzzy there.
Do you believe that you made this request as a private citizen? As a public record request?
Yes. By the time this audio recording was made, I was terminated in the making of this. So I became a regular citizen. There's no way I could have asked for this while I was a police officer.
Okay.
Does that make sense?
Yeah, and sorry, what under normal circumstances you wouldn't normally disclose such a thing to a member of the public because of personnel issues.
We would not release this information to a member of the public, no. We would only release this information to a former police officer asking for their personnel records. So he had been terminated, as he said, and was no longer a police officer, but as his time when he was a police officer, he had a personnel record, which he is now asking for. So we have provided him that because he was a former officer asking for his personnel record, and it was given to him. But we would not release closed session items to a member of the public.
Okay.
Through the chair?
Yes.
Mr. Youngblood, would the complainant has just said that it wouldn't be turned over to him as a current police officer, and you're describing how it's made available to him as a former police officer. Is he correct that if he hadn't been terminated, he wouldn't be given access to this information?
If he had not been, if he was still an employee, then yes, he would still have access to his personnel information. But
okay,
a member
so
of the public, anybody else would
because he
not.
was an employee, not because he is no longer an employee.
Correct.
Great.
Matt, any questions?
No, I think where I'm at is I think we've had similar discussions regarding personnel records before, and I think to me this is a public record. Now, whether or not it's disclosable to everyone or only a given individual, I think is the main question. But I don't think it's not a public record. I do actually think it's a public record. But I just want to get to quickly comment to a point raised by the complainant in the beginning. I think he was requesting some type of signed affidavit or something along those lines. I just wanted to make clear that we can't force people to sign affidavits or to create documents that don't exist. That obviously we can help find public records that do exist, but we can't compel people to make affidavits or sign affidavits or so forth. That's really all I had right now.
Okay.
Thank you. And then I did find that email where that's in question here. If you'd like me to read it, I sent it on. Stacy Youngblood sent this to me on February 5th. If you'd like me to read it regarding his statement about the non-disclosure of information security regarding the make and model of desktop I was asking for. I can read it right off.
Before you read it, is it in our case pack?
Yes, it is. Yes, it is.
What page it's on?
What day is it on? Like, what day did I send it to you? Are you asking me what day
Page number.
I sent it to you?
What
Page number.
Page in our packet.
Oh, how would I find out? How would I find that out?
In the bottom center.
In the bottom center. In the bottom center
Of each page. In the packet on the computer.
Are you not looking? It doesn't sound like you're looking at your packet.
There was a packet.
Are you looking? Are you? Yeah, I sent the agenda to you.
Oh, I have the agenda.
Yeah, and in that agenda is a link to all the records in your case under your matter number. And each page has a page number on it.
Okay, so I'm in the agenda, and I'm now looking at my file number 19145.
Correct. And you want to hover your cursor over that.
Okay, I'm on my iPhone, so okay, I hovered it. Okay, I got it. And then what?
And then if you could direct us to the page number of the email that you're referring to, that we're talking about, that would be very helpful.
Oh,
after hovering, you click it.
Okay, I just figured it out. So let me try to get us there.
Excuse me, may I say something that might be able to clear this up?
Sure, go ahead.
This is Sergeant Stacy Youngblood again. So I believe that Mr. Torres is referring to the email where he has asked for a number of things. One of the things that he has asked for is the make and model and serial number of the recording equipment, which is located at City Hall, that we use to record the closed session items. He was told that he needed to contact City Hall to get the serial number and the make and model of that equipment. He also asked for the serial number and the computer ID and IP address of the computer that we put the thumb drive into at Police Commission office. I
never
told
asked
him
the
that
IP
we
address.
will not release that. I told him that we would not release the serial number of the public to the public for a government-owned computer because our IT department says that we are that would expose us to various attacks giving out that serial number. So if that clarifies a little bit of it.
Yeah, I think it does, and yeah. So, colleagues, how would we like to proceed with this item?
I think we're ready to advance it to the full board or the full task force. It seems like whether the complainant had access to this document in a special case, or whether it's whether his access to the material on the public record is a result of his role, is probably going to be an important factor in adjudicating this case. But there's some other issues like trying to get this data, whether or not the serial number of a computer is a legitimate concern to not disclose. So there are some other factors, but I think that we, using the fact that the document is a public record, even if the information isn't on it, we can find, I'd like to make a motion that we find it as a public record and jurisdiction, and then we'll deal with whether or not the material on the record we have jurisdiction over with the full board.
That sounds good. Is there a second?
I will second that.
Is there a public comment on that motion?
Yes.
Okay. Oh, go ahead.
All right. Go ahead, Anonymous.
Hello. So
Hang on.
first of all, I'd like to say this is not.
Hang on. Sorry. I gotta
Apologies.
typing here. Okay, there you go.
All right.
Go ahead, Anonymous.
First of all, sure. This is not legal advice to anyone. This is also not IT or professional IT or security advice. So two things on there. I think it's very important that the committee, as it is doing right now, separate between whether or not something is a public record as defined in the CPRA, this is clearly a writing about the conduct of public business prepared, retained, owned, or used by a public agency. And that's all that matters for whether or not it's a public record and you have jurisdiction. Whether or not it's disclosable under an exception exactly is a matter for the full task force. It is not really for you here. And that's important because many times people basically argue you don't have jurisdiction because you can't get this, because many of the cases that come before the full task force, at least that I've seen, are about employment termination or contract related or discrimination related cases that all kind of have to do with a special relationship between the requester and the city, or a former special relationship. But that really has nothing to do with whether or not it's a public record. And second, about IP addresses. This came up in one of the SOTF cases, SOTF 19047 and 19044, and your metadata case. And you at that time asked Chief Information Security Officer Michael Maxman to come and explain which parts of that information are truly security sensitive and which aren't. And you may wish to consider having that kind of opinion that's outside of the SFPD again. For example, the IP address is essentially public information when that computer talks to another computer. So it's not necessarily the case that all IP addresses are secret. For example, it's public information what the range of IP addresses which are owned by SFPD are. That information is publicly known in the internet infrastructure. So that's all. Thank you very much.
All right. Other public comments on this motion? All right, hearing none, Madam Clerk, would you please call the roll?
Yes. Member Wolf?
Aye.
Member Wolf, aye. Member Yankee?
Aye.
Member Yankee, aye. Chair Hinsey?
Aye.
Chair Hinsey, aye. The motion to send to the task force passes.
All right. Madam Clerk, would you please call item number 8?
Just a moment. Item number 8, file number 19140, complaint filed by Stephen Malloy against the Department of Human Resources for allegedly violating Administrative Code Section 6721 and 25 by failing to respond to a request for public records in a timely and/or complete manner.
All right. Mr. Malloy, are you with us?
Yes, I am. Mr. Malloy is here.
And someone from Department of Human Resources? Daryl, what we heard from the DHR.
I notified my contact over there, Maggie McHale. I sent her an email notifying her that this case was going to go forward, and then I sent the agenda.
Okay, but we haven't heard from.
I have not heard from anybody from Human Resources.
Okay. In that case, Mr. Malloy, why don't we give you 5 minutes to state the end of the case, and then we'll decide where we go from there.
Okay. I just want to
ready,
make
Mr.
sure,
Malloy?
thank you. I just want to make sure we're all open on your file number, Cheryl, that you did give so that I can reference you and take you through that file. I just want to make sure everybody's all on that now so that I'll walk you through my previous documents, which you loaded for us under my case file number. So we're all there? I just want to make sure everybody has it open so I can reference you.
Everybody looking at the file?
Yep, go ahead.
Yep, we're good.
Awesome. Thank you all. Thank you, Member Hinsey. You're doing a great job today. Appreciate you and everybody else. If you can go to page 40 of 324, which Cheryl labeled P1110, so P1110, you should see in my January 20th email where I kind of did a summary of my case that I gave you a violation timeline there. And I just wanted to reference you on that timeline that my case started originally in November of 2019. On the 5th, on the 6th, Custodian Vong over at DHR pushed back on me to give him a narrower scope. I gave that to him. I pointed out that that's a badgering tactic as I look at it because I don't have to be incessantly questioned and asked for innumerable details that, of course, I don't know because I'm not the one as the custodian of the record. But I, again, did my best to give him information. And then on November 7th, he asked me for a 10-day extension. On November 14th of 2019, he released to me 6 emails. And in those 6 emails, he unlawfully redacted 8, essentially. And he blacked them all out. For your reference, those are in this file on page 253 through 255 out of 324. And that's on page P1323, and then P1324 and P1325. And as you will see on those 3 pages, it's just blacked out. It is not lawfully redacted. We've been talking about that in all of these cases today, and so I'm no different. And Mickey Callahan, who runs DHR, knows how to do a redaction. So I want to back us up a little bit in my document to page 39 of 324, which is P1109. It is right before the timeline that I just took you through. And in there, right at the top of the page, and let's please remember, I wrote this in January. I said, second, City Attorney Herrera and his underling, City Attorney Yank, have unlawfully prohibited SFDHR from releasing all records concerning Stephen Malloy. They are maintaining the records in secret, which stands in willful violation of the Sunshine Ordinance and of the task force. And so this brings us back to our previous case, as we now know, with Ms. Vane and DPH, where the city attorney, and we have that.
Is there something wrong with the transmission?
Sorry, Mr. Warfield, we're not in public comment quite yet. Go ahead, Mr. Malloy.
Thank you. And so all I'm pointing out to you is that this is a systemic pattern with my case. And as I detailed in this email, this is about bias, and this is about retaliation and discrimination. This is about really rooted issues in relationship to my complaint that they have targeted me in every department. The city attorney has engendered official misconduct by directing the clerk not to release the record. The issue isn't that they can't do the record search or that they can't redact correctly. The issue is that they are not releasing the records and they are not redacting correctly because of the malfeasance and of the discrimination that they've exhibited towards me. And so I've just, we've kind of beat this dead horse enough, but I'll take you forward in the document to page 42 of 324, which is on P11-112. You see that I went through in quite detail about I didn't get drafts, I didn't get memorandum.
Mr. Malloy, your time is up.
Okay, thank you.
All right, thank you, Mr. Malloy. Since we do not have a respondent with us, committee members, this is your time for questions. Questions, committee members?
I'll just ask one quick question here to the complainant, just to get some clarity. So, are there some records that you received that were entirely redacted, and are there some records that you did not receive at all, like in nothing at all?
Your answer to the question about the redactions is those are the ones that are on page 253.
Right, I saw those.
Right. So those are not lawfully redacted, and I need those to be lawfully redacted. I don't feel they should be redacted at all. I don't think they should be held in secret. I was an underling in the Department of Human Resources who Mickey Callahan just simply blocked illegally from allowing my investigations to go forward.
Right. My question is, are there some...
So to answer your question about the redaction, I just am asking for those to be lawfully done. In terms of the other records, to answer your other question, I believe, I do not know because I'm not standing over the shoulder of the clerk, that they have many more responsive records but are refusing to release them.
Gotcha.
And I don't know that because I'm not physically able to stand at his computer and audit him. But if we were, I believe we would get them out.
Okay, so essentially your complaint's twofold. One, that there's improper redactions on records that you did receive, and then you're also alleging that there are records you didn't receive whatsoever.
Correct, because we know that Mickey Callahan, those emails are from Mickey Callahan. And so Mickey Callahan, and at the time Susan Gard, who was the chief of policy, were communicating extensively with DPH, which is where I was housed, about me. But we don't see any of those records. But that's impossible because they clearly had to have communicated with Greg Wagner at the time, now Grant Colfax, about me. But they didn't release any of those to me. But I know she talked. Clearly, she had emails and conversations. But he only gave me like that small sliver, and then he stopped completely. He refused to even communicate. He never followed up. And that's when I believe the city attorney also told him, like he told Ms. Vane in DPH, stop. And so they just stopped, which is why they're not here today. They're not talking. They're not releasing records. They're just participating in improper government activity at this point.
Gotcha. Okay. I think you answered my question. Thank you.
All right.
Yeah, thank you.
Josh, any questions?
No questions.
Right. I don't have any questions either myself or our complaining today. So, members, how do you think we would like to dispense with this? Or I should say.
Sure, I'll go ahead and move that the records are public and to refer to the full task force for a hearing. And it looks like you did already find jurisdiction on this, so yeah, so just that.
Do I have a second? Okay, I'll go ahead and second that. Public comment on the motion.
Yes.
Anonymous, go ahead.
Hang on. Hang on.
Sorry.
It's my kitchen timer, sir. There you go.
All right. So I think what's important to notice, and of course this is not legal advice to the complainant or IP or any other professional advice. On page 253, what's really interesting here with respect to 67.26 is you know what some of these lines are going to be and that there's no way they can be redacted because they would not qualify as the minimal possible withholding of information of this document. For example, the from and to and the date lines, when did they communicate? That's not a part, that's not a part of whatever they're claiming, the names, who communicated. So even if the content was protected, even if like the individual sentences here are protected, there's no reason the names of the word from to send, who sent to whom, what dates they communicated, should be redacted at the minimum. That's not to say that more can't be unredacted. And if this is properly redacted, then each and every redaction should have a footnote or other clear reference to a specific justification, and they should be able to stand by that justification when they come to the full task force. Thank you very much.
Thank you.
All right. Public comment on the motion.
Anybody else? It looks like that's it.
Okay, looks like that's it. I was hearing some clicking on the phone, so I was giving some extra time. But it looks like that's it. Public comment is closed. Madam Clerk, would you call the roll for us?
One moment. Member Yankee?
Aye.
Member Yankee, aye. Chair Hensy?
Aye.
Chair Hensy, aye. Member Wolf?
Aye.
Member Wolf, aye. The motion passes.
We can call the next item.
Item number 9, announcements, comments, questions, and future agenda items by members of the complaint committee.
All right. Any announcements or comments from members? I've got one. When you guys are done.
I was just going to thank Member Wolf for coming on his last day. So thank you for joining us.
You got it.
Yeah, Josh, we're going to miss you.
That was mine too. For thanking Member Wolf for his service on Vice Chair Wolf actually for his service on the task force, and this is his last meeting. Thank you for your service. You've done an excellent job with us. So,
cheers. It's been a pleasure to serve the city of San Francisco and call the city home for almost 20 years.
You're embarking on a new adventure.
Always.
Yep.
Chair Hensy, I think we want to remind people of the October 7 task force hearing date.
Sure, I'll go ahead and give that date again. So, if your case was heard today and we moved it out of committee, you are likely to be heard at the October 7th full task force meeting, which begins at 4 p.m. You'll be hearing from our administrator with an agenda for that meeting fairly here, actually.
I'm sorry? I didn't hear that. What did you say?
I was saying, folks will be hearing from you fairly soon with details of that hearing.
Yes, they will.
So yeah, and the next complaint committee hearing is when? So?
Let me take a look at my calendar. So the next complaint committee meeting will be October 20 at 5:30. That will be the third Tuesday of the month.
This committee is meeting monthly again.
Yes, as far as I've spoken with Chair Wolf, and yes, we are going to continue to meet.
Okay. All right. Next on our agenda.
Item number 10, adjournment.
Okay, is there a motion to adjourn?
I'll move to adjourn.
I'll second.
All right, I have the time at 7:14 p.m.
Good job, everyone. Good to see you.
Cheers.
Good luck, Josh.
Hey, Josh, don't be a stranger.
Good luck, Josh.
All right, sounds good.
Hey, Josh, just one request. Can you let us know if you're moving writing?
Okay.
And just note that you're going to have to complete your leaving office form 700.
All right, sounds good.
Okay, thanks a lot.
Okay.
All right, cheers. Bye.
Bye.
Good night.
All right, see you guys later. Next
Stop
hearing.
recording.
I'm doing that right now. Seriously, I don't want to